Hello, my name is Jennifer George, and I am an attorney at Isaac Brandt Levin & Teeter in Columbus, Ohio. Today, I wanted to speak to you about an area of property law. Now, whether or not you own property, actually, this area of the law could very well affect you. So if you don't own property, don't turn off this video. The area of law is called adverse possession, and it's actually surprising, I think, for most people to learn that such an area of law exists and how it affects us on a daily basis. And the reason I think it's particularly applicable to today's society is because it's no secret that we're getting larger and larger, and because of that, we're oftentimes building closer and closer. So what is adverse possession? In short, adverse possession is a way for someone who doesn't have legal title to land to actually become an owner of that land. Or inversely, if you do have legal title to the land, you can actually lose legal title to that land to someone who does not have it. And what the law looks at as far as reasoning or policy behind why have adverse possession is it's a way to stabilize our boundaries. Like I said, we're all building fast. A lot of times you could have two plots of land. You could have a house built on that land and never truly have a survey done. Or perhaps you put up a fence, but you're fairly certain based on your mind's eye and based on activity that happens around the property on a daily basis that that is your property line and that's where you erected that fence. Well, your choice to erect an fence in that area could have long-lasting effects, and that's where adverse possession comes in. So if for instance, someone once says, actually, that is my land, where you say it's your land, that is my land, the law is going to ask them to show 5 things, and there are 5 things they need to prove to show that they get title to that legal title to the land that's actually yours. And the 5 things are whether there is actual possession of that plot of land, which means, is there physical appearance of activity on that land, whether it's planting plants, trees, putting up a fence, whether that person's there on a daily basis. Next, they look at whether there's what's called open and notorious, and that is essentially similar to actual possession, which is when someone drives by, does it look like someone lives on that land? Are you doing to that land what a real owner would be doing to that land? Next is something called hostile, which isn't truly what it sounds like. Hostile is pretty much that you are acting as if you own that land when it's really not yours. It doesn't matter whether it's intent to do that or whether there's no intent to do it. Maybe it's by mistake. Next, it has to be exclusive, which means if you're acting a certain way on land that's not yours, that you're not actually sharing that with who is the rightful owner of it. And finally, it needs to be continuous, which means there shouldn't be huge breaks of time in which you're being active on that land. And that is really going to be regarded depending on what type of land it is. For instance, is it a field where crops are grown? Or is it a residential property where you should be out there on a daily basis or pretty close to it? And the next kicker is that there's a long period of time for which these 5 things need to go on. It's actually 21 years under Ohio law. And Ohio is one of the states where adverse possession is a true doctrine that is enforced by the Ohio courts and has recently been by the Ohio Supreme Court. So a legal tip is take note of where your property lines are. Take steps to verify them. If you think there's irregular activity that shouldn't be going on, take steps to put others on notice that in fact there are. If you have any questions about this matter or any other legal issues, please don't hesitate to call us at Isaac Brandt Levin & Teeter, 614-221-2121. Thank you.